Greetings, 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 greetings. It is I, King Clifford Jefferson, a Senator Godfrey, the fifth Canavan Jew, the son of Folk, the ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England as the Vicar of Christ, or Malachi Zodok, the King of Righteousness. It is November 5th, 2024, which is equivalent to the Berber year 2974. I greet you in the name of all the past martyrs, saints, heirs, successors, and the known predecessors. This is a beautiful time this month to be alive, as my Archbishop always say. It's a great time to be alive. For some great changes are taking place for the benefit of the English Anglo-Saxon Berbers. There's a lot of information out there that people choose to have, but unfortunately, it's not the right information. And as Nobujali says, he who writes your book sets your timeline. The time never was when man was not. At the life of time when man began, the time will come when man will be no more. So it's very important to realize what's going on here in North America and why it is happening here in North America. The purpose and intent. So this lecture is called Waste, Common Law, the Anglo-Saxon Property. Waste, Common Law, Anglo-Saxon Property, meaning waste as defined under the common law of England. Okay? Very important because we all know what it means to waste something, right? To use it other than the purpose and intent it was used, or to just simply don't make use of it, all right? Or to use it for something other than the intent it was created. Okay, so it's very important that you understand your place, all right? Because we here in North America, the majority of our leaders in regards to representation actually represent a wasteful people. Time is the most dangerous element. If you don't use it wisely, you get in trouble. Our brothers and sisters have not used their time wisely. They are a wasted people in a wasteland. Okay? Very important to understand that you are a waste people in a wasteland practicing ways of that are simply just a waste of time. Greetings, Candace Middleton. Glad you was able to join me today. All right. So if you watched my last lecture, I hope you enjoyed that one. All right. It shed a lot of light on citizenship. All right. And citizenship is very important because it determines your status, whether you're a national or you're a foreigner. And we know that corporate domicile determines the status of the citizens, being that corporations are citizens, and the state in which they are domiciled or take up residency, which is different from citizenship. And it's very important to understand that if your residency or domicile has nothing to do with the country, then the only purpose and intent that your domicile residency fits in the requirement has to deal with an employee of the state. So in actuality, all citizens of the United States and of their counterparts, their states, are simply employed to be citizens. Did you hear what I just said? You are simply employed to be citizens if you reside in a territory within the state or the United States. Because they determine your status within that state. You don't determine that status in the state because your status in that state only has to do with the purpose and intent why you're there. If it doesn't denote to being a national in a country or a foreigner in that state or the United States in which you're a citizen, which one means you're a foreigner and one means that you're national citizen of that country, then why are you there? The only intent that can be, if it wasn't for the first, the former, and the latter, would be employment. Okay, so you must comprehend how important these lectures are. All right. Today's gonna be a beautiful lesson, as always. My lessons are beautiful, but nonetheless, people choose to, seek their own fancy, and as a result of that, they're living in a fantasy, a world that's not real. All right. He who writes your books sets your timeline. Okay. So without further ado, let's get started. Promise I won't hold you long. Where do I want to start? The exciting part. Let's start in Rutgers University. The representative who's assisting the Third Tibetan Church of England as counsel and advocacy is Yasmin Hafez. Peace and blessings to her for taking her time out of her busy schedule to defend and take upon such an undertaking. All right, so with that in mind, I just want to do a little background on Rutgers and how important Rutgers is to this conversation we're having here today. Okay, so let's go there. Rutgers University at one time was called Queens College. Pay very close attention to what's being said to you. Rutgers University, officially Rutgers, the State University of New Jersey, is a public land grant research university consisted of 3 campuses in New Jersey. Chartered in 1766, Rutgers was originally called Queens College. It was affiliated with the Dutch Reformed Church and is the 8th oldest college in the United States, the 2nd oldest in New Jersey after Princeton University, and one of the 9 colleges that were chartered before the American Revolution. Very important. The motto for Rutgers University, contrast to the Latin, I'm not going to even try to pronounce that. In English, it's the sun of righteousness shines also upon the west. The sun of righteousness shines also upon the west. Okay? Everyone needs to remember that. Our representative or advocate has a double major in English political science. So this is very important for her to know. All right? Very important for her to know. So if she's watching this podcast, inshallah, that she'll be able to make the connection as we're going to make the connection here this evening. This evening. Through several years of efforts by Theodorus Jacobus Fringlinghusen, forgive me if I'm pronouncing it wrong, and Jacob Rusten Hardingberg, later the college's first president, Queens College received its charter on November 10th, 1766, from New Jersey's last royal governor, William Franklin, the son of Benjamin Franklin. Everyone needs to understand that. Queens College, now called Rutgers University, got their first charter from William Franklin, the illegitimate son of Benjamin Franklin. Okay? Very important. The illegitimate son of Benjamin Franklin. They were from the German house, all right, of House of Handover. Okay, King George III was from the House of Handover and what's it called? Colin Saxonburg. Okay, German houses. They got their start from the House of Stuart, which got their start from the House of Tudors. House of Tudors is where the United States still originated from, representing the 6 countries that make up those 6 nations who immigrated here to North America and became what they call your national citizens, i.e. naturalized citizens, because they're now national of this country, whatever at the time, whatever this country was called. They were foreigners, okay, immigrating here. Very important that you keep that in mind, all right? So enough about Rutgers. We know what's called Queens College. It was chartered by William Franklin, the son of Benjamin Franklin, okay? I'm more concerned about the motto, okay, of Rutgers University. Being that King James wrote his translation of the Bible, which actually came about at the time of what we call the Reformation or Reformation Day. Reformation Day is October 31st. Okay, this goes into the history of the Protestant Church. This also goes into the history of the 39 Theses. 39 Theses just goes into what we call the history concerning the Protestants and what we call the month called Halloween, okay, or Hallows Eve or All Saints Day, okay. Very important for you to understand those days because they have reference in Anglo-Saxon history in which we honor those days of our martyrs, our saints, those who have passed on, as well as those who are still here, okay, who live in the sanctified life or the life of sanctity, all right. So Rutgers' motto, sol estate et ostentatum illustra. Pronouncement, if I'm pronouncing it wrong, please forgive me. Translated in English as the sun of righteousness shines upon the west. Also, it derives from the motto of the University of Utrecht in the Netherlands, with its sol lustate illustris nos, translated as the sun of justice shines upon us. It is a reference to the biblical text of the book of Malachi, chapter 4, verse 2, and the book of Matthew, chapter 13, verse 43, which we'll review in a second. This motto appears in the university seal pictured above, which is also derived from that of the University of Utrecht and depicts the multi-pointed sun. Okay? This is very important that we comprehend this. All right? We're going to look at the symbolism and the meaning and the purpose of why Rutgers was there and the origin where Rutgers stemmed from, because it got its charter from William Franklin. And William Franklin was the illegitimate son of Benjamin Franklin, one of your founding fathers. And at this time, William Franklin was a loyalist, okay? His duty was to the crown. And in lieu of that duty to the crown based upon his allegiance, he the one who came about what they call the two-road speech, which we'll talk about in a second. So it's very important we pay attention to the biblical references of what Rutgers means to the English people, okay? And about the Enlightenment, about what took place in the latter days, going back to the Middle Ages, and that individual representing enlightenment, all right, being manifested here in what we call North America based upon being studious and learning, okay? Our representative advocate, Jasmine Hafiz, represents her name. Yasmin represents God's gift, and her last name represents guardian or protector. Okay, and she got a double major in English political science. Okay, and English political science is rooted in the social political science of the English people. Okay, and we know Rutgers University was chartered by the kings of Scotland, known as the kings of Great Britain, who got their start in 1603. Okay, in 1603 through the Union of the Crown. And that was only a result of their connection to the House of Tudors under Henry VIII. Okay, so I don't have time to continue to revisit that. So hopefully, those who watch my past lectures, you'll be able to make the connection. Now let's deal with the verses in your biblical references, making reference to the Son of Righteousness and bringing healing in His wings to those or all of us here in the West. Okay, let's view the scripture. Matthew 13. So it said, Matthew 13:43. That's where we're going to go there first. All right. Everybody know that thought? Matthew 13, chapter 13, verse 43. We're going to read a little bit of uh, the verses before that. Chapter 13, the same day when Jesus out of the house and sat by the seaside. Okay, so he came out of the house. A great multitude was gathered together unto him, so that he went into a ship and sat, and the whole multitude stood on the shore. And he spake many things to them in parables, saying, Behold, a sower went forth to sow. A sower went forth to sow. And when he sowed, some seeds fell by the wayside, and the fowls came and devoured them up. Some fell upon stony places where they had not much earth, and forthwith they sprung up because they had no deepness of the earth. All right, these are weeds talking about. And when the sun was up, they were scorched, and because they had no root, they were withered away. And some fell among the thorns, and the thorns sprung up and choked them. But others fell into good ground and brought forth fruit, some of 100-fold, some 60-fold, and some 30-fold. 9. Who has an ear to hear, let him hear what the Spirit of the Most High say to him. 10. And the disciplines came, and the disciples came. If you're a disciple, that means that you must be disciplined. You must be able to follow instructions. And the disciples came and said unto him, Why speak thou unto them in parables? Okay? Speak to them in a way or a manner which they could not understand. In other words, a different language. Okay? A different language. He answered and said unto them, Because it is given unto you to know the mysteries of the kingdom of heaven, but to them it is not given. For whoever has, to him shall be given, and he shall have more abundance. But whoever has not, from him shall be taken away even that he hath. Therefore speak I to them in parables, because they seeing not, and hearing they hear not, neither do they understand. So you can talk to them till they blue in the face, and still they can comprehend not. Man, no, but what they say, man, no, not by being told. Therefore speak I to them in parables, because they seeing not, and hearing they hear not, neither do they understand. And in them is fulfilled the prophecy of Isaiah, which said, by hearing you should hear, and should not understand, and seeing you should see, and not perceive. Okay? So the thing that you see and physically see and physically hear, that was not should be your comprehension. Okay? You should be comprehending things that you can't see and can't hear. Okay? For lies there in truth. For this people's heart is wax gross, and their ears are dull of hearing, and their eyes they have closed, lest at any time they should see with their eyes and hear with their ears, and should understand with their heart, and should be converted, and I should heal them. Okay? So this understanding or comprehension cannot come from your five faculties. It must come from consciousness, understanding. Okay? 16. But blessed are your eyes, for they see, and your ears, for they hear. For verily I say unto you, that many prophets and righteous men have desired to see those things which you see, and have not seen them, and to hear those things which you hear, and have not heard them. Hear ye therefore the parable of the sower. When anyone heareth the word of the kingdom, and understandeth it not, then cometh the wicked one, and catches away that which was sown in his heart. This is he which received seed by the wayside. But he that receiveth the seed into stony places, the same is he that heareth the word, and anon with joy receiveth it. Yet has he not root in himself, but endures for a while. For when tribulation or persecution arises because of the word, by and by he is offended. Okay? Hard-headed make a soft butt. He also that receiveth seed among the thorns is he that hears the word, and the care of this world, and the deceitfulness of riches chokes the word, and he becomes unfruitful. Okay? What profits a man to gain the whole world but lose his soul? What will he give in exchange for his soul? But he that receiveth seed into the good ground is he that hears the word and understands it, which also beareth fruit and bringeth forth some as hundredfold, some 60, and some 30. So you get what you put in. Okay? The gifts of understanding are the treasures of our Creator. All right? These are the gifts of understanding through taking time to study. Okay? 25. But while men slept, his enemy came and sowed tares among the wheat and went his way. But when the blades were sprung up and brought forth fruit, then appeared the tares also. Okay, examination time. So the servant of the householder came and said unto him, Sir, didst thou now sow good seeds in thy field, from whence thou hadst it tares? He said unto them, An enemy has done this. The servant said unto him, Wilt thou then that we go and gather them up? But he said, Nay, lest while ye gather up the tares, you root up also the wheat with them. Okay, they all mixed together. Let both grow together until the harvest. And in the time of the harvest, I will say to the reaper, Gather thee together first the tares, and bind them in bundles to burn them, but gather the wheat into my barn. You hear this? This is a separation. Okay? Another parable put his forth unto them, saying, The kingdom of heaven is like to the grain of mustard seeds, which a man took and sowed in his field. Which indeed is the least of all seeds, but when it grows, it is the greatest amongst herbs, and becomes a tree, so that the birds of the air come and lodge its branches thereon. Another parable spake unto him then. Another parable spake he unto them. The kingdom of heaven is like unto leaven, which a woman took and hid in 3 measures of meal, till the whole was leavened. All these things spake Jesus to the multitude in parables, and without a parable spake he not unto them. Once again, all these things spoke Jesus unto the multitude in parables, and without a parable spake he not unto them. So that means that he spoke everything, but the people couldn't understand it. Why? Because the people didn't take the time to understand what it is that he was saying to them. All right? They was using interpretation based upon how they was used to interpreting things. Okay? That's not always the way. Okay? As we can see, our advocate, Jasmine, didn't take a double major in political science of the body of politics of Islam. She took a double major in the body of politics or the political science of English. Okay, it's very, very important. So we must understand it from that parable, that connection. Our Jesus was King Edgar the Peaceful. Okay, very important. Coming to my closing in this chapter. 35, that it might be fulfilled which was spoken by the prophet, saying, I will open my mouth in parables. I will utter things which have been kept secret from the foundations of the world. 36, and Jesus sent the multitude away and went into the house. And his disciples came unto him, saying, declare unto us the parables of tares of the field. Now they want to know what's going on. He answered and said unto them, he that sows a good seed is the Son of Man. The field is the world. The good seeds are the children of the kingdom, but the tares are the children of the wicked ones. Okay? The enemy that sowed them is the devil. The harvest is the end of the world, and the reapers are the angels. Y'all better listen to what I'm telling you. Okay? No one is exempt from this judgment. All right? As therefore the tares are gathered and burned in the fire, so shall it be in the end of this world. The Son of Man shall send forth his angels, and they shall gather out of his kingdom all things that offend, and them which do iniquity, and shall cast them into furnace of fire. There shall be wailing and gnashing of teeth. 43. Then shall the righteous shine forth as the sun in the kingdom of their Father. Who has an ear to hear, let him hear. Okay? Once again, he who has an ear, let him hear. Let's go to Malachi 4. Judgment and covenant renewal. Now remember, this is what the motto for Rutgers University. The sun of righteousness is shining in the west. We're in the west. Okay, we're in the west here in North America. All right. You got the east side and you got the west side. The west side, the east side is called Los Angeles, Los Angeles, versus the east side, the Garden of Eden. Okay, so these connections have to be made. We're talking about what's going on right here, the destruction that's going to take place right here, the salvation that's what's going to happen right here. Judgment and covenant renewal. 4. Surely the day is coming and will burn like a furnace. All the arrogant and every evildoer will be stubble, and the day that is coming will set them on fire. You hear that? Says the Lord Almighty. Not a root or a branch will be left to them. But for you who reverence my name, the Son of Righteousness will rise with healing in his rays, and you will go out and frolic like well-fed calves. Then you will trample on the wicked. There will be ashes under your soles of your feet, and on the day when I act, says the Lord Almighty. Remember the law of my servant Moses, the decrees of the laws I gave him at Horeb for all Israel. 5. See, I will send the prophet Elijah to you before that great and dreadful day of the Lord comes. He will turn the hearts of the parents to the children, the hearts of the children to their parents, or else I will come and strike the land with total destruction. Okay? Why this is important? Why is Malachi and Matthew the model for Rutgers University? Okay? Rutgers University was chartered by William Franklin William Franklin was under the authority of the crown, okay, before he was arrested by William Patterson. Okay, remember that name, William Patterson. Let's go to an article dealing with William Patterson. Okay, very important. The Jefferson Monticello, divided loyalties, Benjamin and William Franklin. Everyone see that. Benjamin and William Franklin, divided loyalties, the Jefferson Monticello. I'm just going to go to where I would need to go. Everyone give me a thumbs up if you like the content. Right here. The era of good feeling between father and son would come to an end with the advent of the American Revolution. Benjamin Franklin, sometimes referred to as the reluctant revolutionary, hoped at first the differences with the British could be resolved. When he did not join the revolutionary cause, though, let me start over. The era of good feeling between father and son would come to an end with the advent of the American Revolution. Benjamin Franklin, sometimes referred to as the reluctant revolutionary, hoped at first that differences with the British could be resolved. When he did join the revolutionary cause, though, he was all in and pursued goals of freedom and liberty with vigor. He expected William could be persuaded to do likewise. Had William always followed his father's lead before? This time Benjamin would be bitterly disappointed. In August 1775, Franklin traveled to New Jersey to convince William to join the rebellion. Y'all better listen close. Greetings, Noble. I'm doing the class right now. Thank you. All right. So it says, when he did join the revolutionary cause, though he was all in. When he did join the revolutionary cause, though he was all in and pursued goals of freedom and liberty with vigor. He expected William could be persuaded to do likewise. Had William always followed his father's lead before? This time Benjamin would be bitterly disappointed. In August 1775, Franklin traveled to New Jersey to convince William to join the rebellion. He told his son he would be accepted with open arms by those opposing the king and could easily win a generalship in the army forming under George Washington. William refused, remarking that if his father was determined to set the colonies on fire, you hear this? On fire. You hear this? On fire. The same thing you read about in Malachi 4 verse 1 through 5. Okay? And was it Matthew 13 verse 43. All right? We're talking about fire on people. They're gonna feel like they on fire when this heat get to them. Okay? He expected William could be persuaded to do likewise. Had William always followed his father's lead before? Now his biological father, he was following the father of the nation. Okay? The father of the nation. When your father come home and his house ain't right, you gonna have a problem. When Jesus come home, he told you, all right? He told you, gather all those in my barn. Okay? That's on my land. That's part of my house. He chose you. He expected William could be persuaded to do likewise. Had William always followed his father's lead before, this time Benjamin would be bitterly disappointed. In August 1775, Franklin traveled to New Jersey. New Jersey, y'all, represents the crown in 1776. William, New Jersey convinced William to join the rebellion. He told his son he would be accepted with open arms by those opposing the king and could easily win a generalship and the army forming under General George Washington. William refused, remarking that if his father was determined to set the colonies on fire, he entrusted he trusted that he would take care to run away by the light of it. As a loyalist, William believed America's best chance to succeed lay in remaining with Britain. He also believed most Americans would not support the rebellion. William Brake, with his father, became very public with his two-rose speech to New Jersey legislature, urging them to refuse to endorse the newly formed Continental Congress and take the road to prosperity as a part of England rather than the road to civil war and anarchy. His efforts were to no avail. Did you hear this, y'all? He went, what state? He went to New Jersey. New Jersey was the crown. They was telling all those who were your founding fathers of this nation that if they took the position that they did take, when it ever came out, it was going to be like fire on their butt. Okay? It was going to be like fire on it. And that was the model that they put in Rutgers University, which was a charter given by William Franklin, who was the last world governor on the crown. Okay, the last world governor of the crown. Y'all better pay attention to this heat, y'all. All right, so let's move on. Where do I want to go? Let's go right here. Waste law, because this lecture is called Waste Common Law of the Anglo-Saxon Property. You have laid waste to the lands that actually belong to the Anglo-Saxon Berbers. Okay? You have destroyed the land belonging to the Anglo-Saxon Berbers. Okay? When I say Anglo-Saxon Berbers, I'm talking about those who descended down from Edward I, the son of Henry III, the son of John, the son of Henry II, the son of Godfrey the fifth Caliban Jew, the son of Folk, the ruler of Jerusalem. Okay? Because Jesus was the son, king of Jerusalem, oneself, the king of Jerusalem, the king of peace. All right, we must comprehend that. So let's look at the concrete that's going to bring heat to your founding fathers and all those who are acting on behalf of your founding fathers. Waste is a term used in property law to describe causes of actions that can be brought in a court to address a change in condition of real property brought about by a current tenant that damages or destroys the value of that property. I repeat, waste is a term used in property law to describe a cause of action that can be brought in a court to address changes in conditions of real property brought about by the current tenant or the current landlord, whichever, or the current tenant that damaged or destroyed the value of that property. A lawsuit for waste can be brought against a life tenant or a lessee or of a leasehold estate, either by the current landlord or by the owner of a vested future interest. Okay? The holder of the executory interest, however, has no standing to enforce an action for waste, since his future interest is not invested. There are several different kinds of waste under the law. Okay, let's review. Voluntary waste. Voluntary waste, sometimes called affirmative waste, is a change made to the estate that intentionally or negligently causes harm to the estate or depletes its resources unless this depletion is a continuation of pre-existing use. Okay? That's one form of waste. Example, if there are copper mines on the land, the current tenant can continue the mining operation to the point of extracting all the valuable copper. If there was no such mine there originally and the lease did not anticipate the mine excavating property would constitute waste. Okay, so if you just drilling to be drilling to find something, you don't know if it's actually there, then you're just wasting time, wasting sources, and you're wasting resources. Okay, we must understand. We have now permissive waste. Permissive waste is a failure to maintain an estate. All right, either physically or financially. Rather than requiring some bad act of the part of the tenant, this requires a failure to maintain ordinary repairs, pay taxes, or pay interest on the mortgage by the live tenant or the leasee or leasehold estate. Okay? So this falls under contract law, tort law, trust law, okay? Inheritance. All this is relevant. We must comprehend. You'll never hear it anywhere else. Okay? Ameliorative waste. If I said it right, ameliorative waste. Ameliorative waste is an improvement to an estate that changes its character, even if the change increases the land value. Under English, you hear that, y'all? Under English common law, when ameliorative waste occurs, the interest party can recover from the tenant the cost of restoring the land to what? Its original condition. This is based on traditional common law jurisprudence, presuming that the grantor intended that the property to be kept is in the original condition. Okay? Cool. This is heavy. One of the remedies for waste is treble damages. Okay? I'm not going to go any more into this, understand what waste law is. But one of the recompense, or one of the remedies for acts such as the couple mentioned here is treble damages, meaning being paid for the harm, being recompensated for the harm as a result of the damage that was done to your property, to the grantor's property. In this case, it would be the king's property. Okay? Very important. So now we know what waste law is, right? There's no confusion about what waste law is. All right, since there's no confusion about what waste law is based upon the common law, we ain't talking about trash floating on the ground or not picking up your garbage disposal or garbage floating in the reservoir. We're talking about damage to the owner's property or damages as a result of not of managing that property as ordered by the owner. Okay? It's very important that you understand where I'm going with this. All right? Very important. And the only way you can understand that is based upon common law precedents. Okay, so let's go to it. This is not from a, 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 a writ submitted to a Supreme Court of the United States or a state. It's not an appellate court from a state or any type of thing like that. This is from an actual claims court on the state level in New Jersey, Superior Court of New Jersey in 1999 in Monmouth County. All involving waste law as told under the common law based upon the examples that we examine. Okay? And the remedy for that is not only return of the property by way of what we call reversion or amendment or ejectment or however it could be done, as well as damages. Okay? Damages. Birch versus Hanley. Superior Court of New Jersey Law Division Special Civil Part in Monmouth County, April 28, 1999. Monmouth County borders Middlesex County. Okay? Monmouth County borders Middlesex County. It also borders Mercer County, where the state of New Jersey is corporately domiciled. Okay? But we are corporately domiciled in Perth Amboy, where the Crown was incorporated based upon the Articles of Incorporation as set forth by the Crown in 1776, which based upon the articles in its incorporation said that its primary business that would operate under the Crown will be indefinite, which means it will be forever. Okay? It's very, 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 very important. Let me second, let me pull something up. New Jersey Revised Statute, Title 2A, Administration of Civil and Criminal Procedures. 2A deals with civil and 2C deals with criminal. Okay? But 2A deals with the administration of the civil and criminal justice. Very important that you understand that because this particular statute that we're talking about was an amendment of the laws that were created by ancestors who were residing as the minors of the plantation in the Crown, namely who? King Edward I. Okay? King Edward I was the king who put statutory law in place, which was amended or changed to fit the coming times. Okay, such is under Title 2A, Administrative of Civil and Criminal Justice. This is the administrative statute governing the common law of our ancestors going back to the plantations in the Crown. Okay, there's no disputing this. Okay, I'm going to show you. Without even getting into the statute itself, let's just go to the case law. All right, to validate the statute and everything that the statute entails and how what the statute entails, where it derives its authority from. All right, very, very, very important. Birch versus Hanley, Superior Court, New Jersey, Special Civil Part, So this deals with landlord-tenants. Special civil parts deals with landlord-tenant matters. Okay? Very important. Mark A. Sullivan Jr., judiciary judge. What was it? He's the judge of the court. All right, everybody hold that thought. What y'all need to realize that this case is from 1999. The contents of this case that was issued in 1999 and not an appellate court or Supreme Court on some type of certification or writ of mandamus or something like that. This is from the actual claims court in New Jersey, governed New Jersey Revised Statute annotated, which is annotated of New Jersey Revised Statute, which is under the same statute. If you read it in the annotated or you read it under the revised statute, the language will still be the same. And it goes on to say that this application concerns the continued viability of New Jersey Revised Statute annotated 2A65-3 and awarding landlord treble damages for waste committed by tenants. The statute in question provides a civil action may be maintained in the Superior Court against the tenant, and upon finding that waste had been committed, treble damages should be assessed or granted, and the defendant should lose the thing or place wasted. So that means that if land is being wasted and is not being managed right, and the claim is brought by a party or an heir, because the statute does involve an heir, that means that you're not only going to use the property by way of injectment, all right, you can also be fined treble damages. Does everyone understand that? All right? Does everyone understand that? Give me a thumbs up if you understand. All right? We just started out with the case. Watch where they go with it. Based upon the statute, you can get paid treble damages if somebody did waste to your property. All right? In a nutshell. What is the source of the statute based upon the right to be paid treble damages? All right? What is the source of the statute? Let's look at what it says. Although the genesis of this statute dates back to England, when the Statute of Marlborough or Marlborough was enacted in 1267, there is very little recent case law on the subject. But yet you talk about it in 1999. That's got to be funny. You talk about it in 1999, okay, about a statute that dates back to the time in England, going back to the kings of the Plantagenet crown. Specifically who? Edward I and Henry III, his father. In 1950, the United States District Court for the District of Delaware ruled that New Jersey courts did not apply the statute to common law actions. There's a reason for that, because they're not incorporated under the common law. They were incorporated based upon Title 52 of the New Jersey Revised Statute, which is temporary and ceremonial, based upon the constitutional requirement under paragraph 6, Article 4, Section 4 of New Jersey's 1947 Constitution, which only deals with bills, and joint resolutions. So New Jersey government and the continuity of New Jersey government is not based upon the Constitution, it's not based upon the legislation, but the enactment of joint House resolutions and bills that allow them to do what they do based upon their citizenship as a result of them being residents in the state in which they live in. Why? Because they are employed to be what? Everyone said? Citizens. They're employed to be citizens. So they didn't involve the common law, because if that was the case, they would have had to involve the law of the country. Okay? So foreigners wouldn't even fit that requirement. Let's continue. The within action is a common law claim for rent and intentional damages by plaintiff's landlord against his former tenant. Defendant is in default for failure to appear. Okay? As proof for hearing, plaintiff requested treble damages pursuant to the above statute, which he found the Department of Community Affairs Truth in Renting pamphlet. Okay? Were the court to simply follow the Fox case, treble damage arguably would not be permitted. The decision in Fox Super, however, was based upon the decision of the New Jersey Court of Chancery. And this court, it stated that the section, I'm gonna read it right here. Everyone pay close attention. The section of the revised statute on which complainant relies is a relic of the Middle Ages taken from the Statute of Gloucester by Edward I, enacted under 1278. Governor Patterson followed the Statute of Gloucester and other ancient English statutes in drafting an act for the prevention of waste, which was passed by the legislature March 17, 1795. His statute has retained a place in our hooks, and with minor changes now appears in Title II of our revised statute as Article 1, Chapter 79. This is Article 2A. This is the statute we're talking about. That's it. Title 2A. This is what he's talking about. All right. So, treble damages can be paid under 2A, or was it 2A 65-3. Okay. If the landlord finds that damages has been done to the property, okay, you can get triple damages under the common law. But New Jersey don't practice common law because they don't have common law citizens until we came back. Okay? Very important for you to understand that. Let's see another statement. It says later at page 461, he states that an action of waste on the Statute of Gloucester was already a rarity in Blackstone days. The usual remedy for waste was an action on the case, a personal action. This was true even though the action on the case of recovery was confined to single damages. Okay? To single damages. So these are a bunch of states and their rulings concerning waste and remedy based upon ranging from single to treble damages. Okay? It's very important that this case be understood. Let's see. Now they got a couple of cases referenced in here. I'm not going to read all of them. I'm going to go right here. And Evergreen Ventures, the Statute of Marlborough, enacted in 1267, restricted the use of estates for years of life for the protection of future owners of the land. You hear that? The Statute of Marlborough, or Marbridge, enacted in 1267, restricted the use of an estate for years or for life for the protection of future owners of the land. The Statute of Gloucester, enacted in 1278, provided for the treble damage for waste. All right, not just 2A 65-3, which is the under New Jersey Administrative for Criminal and Civil Procedure, But it goes back to the Statute of Gloucester, which we'll review in a second. I said the Statute of Gloucester Act of 1278 provided for treble damages for waste. A third English statute on waste, the Statute of Westminster II, enacted in 1285, expanded remedies for waste to joint tenants and tenants in commons. Let's see. Supreme Court of Oregon found statutes still to be applicable in Bolstein versus Lamb. All right. It appears to this court that the affirmative act of the legislature in 1948 of adopting New Jersey revised statute indicated 2A 65-3 and making it applicable to civil actions and Superior Court was to keep the statute viable under the new Constitution and to remove the restrictions that is not be applicable to common law actions. So I repeat, it appears this court that the affirmative act of the legislature in 1948 of adopting New Jersey statute indicated 2A65-3 and making it applicable to civil actions and Superior Court was to keep the statute viable under the new Constitution of 1947 and to remove the restrictions that does not be applicable to common law actions. Okay? We must understand what's going on. All right? This is a 1999 case. And the civils in a special civils division. All right. That does not mean that the statute is inclusive and its applicability to the damage by tenants. Clearly, landlords who avail themselves of their right to charge damages against a security deposit pursuant to Title 46, colon 821.1, have elected a different remedy and can now also have the benefit of treble damages. Okay? So under the common law, you can get treble damages. Under a statutory amendment to that law, you cannot. Okay? So we must understand why we go back to the ways of our forefathers and the laws of our forefathers, which is what? The common law. Very important. So they mentioned 3 statutory enactments that were passed by the Plantagenet King Edward I and Henry III. The Statute of Gloucester, the Statute of Westminster, and the Statute of Marlborough. Okay? Where is that? Right here. The Statute of Marlborough, 1267, the Statute of Gloucester, enacted in 1278, and the Statute of Westminster II of 1285. All these are enacted based upon the anarchy that resulted from a collapse as a result of what we call the wardship. All right, I don't have time to break that down. All those who remember the historical narrative to be able to take it from there. Okay, so all this goes back to the breakdown or the civil anarchy. We understand that when William Franklin presented the argument to Benjamin Franklin and those who were opposing their position as loyalists to the crown, they said that one road would lead to fire and one road would lead to prosperity. And that road will be with England because England was controlled by the crown. They didn't say Great Britain. They didn't say Scotland, Ireland, France. They said England. Well, that's all. So the Statute of Gloucester, the Statute of Marlborough, as well as the Statute of Westminster were all incorporated under New Jersey Revised Statute 2A, dealing with the administrative of criminal, civil and administrative procedures. Okay, so those laws are right here incorporated in the state of New Jersey. The case just said it. All right, the case just said it. The section of the revised statute on which complainant relies is a relic of Middle Ages, taken from the Statute of Gloucester by Edward I. Governor Patterson followed the Statute of Gloucester and other ancient English statutes and drafted an act for the prevention of waste, which was passed by our legislature March 17, 1795. His statute retained a place in our hooks with minor changes and now appears in Title II of the revised statute as Article 1, Chapter 79. Did you hear that? You must comprehend that. Let's go to another case. This is from the Court of Chancery, not appellate court, not the Supreme Court, but the Court of Chancery in New Jersey. So we got one from a landlord tenant court and special civil parts. Now we got the Courts of Chancery, which is the Court of Equity. Okay, all these are ruled by the King's Court or the King's Bench. Back in our days, it was called Wittenmont, which was actually the government of the Berbers. Okay, we must comprehend that. Kinloch versus Court. You can't hide from this truth. Court of Chancery. So we don't need to appeal this. It's right here in the court where the matters involving criminal and civil proceedings involving your kings. This is where this is the court. All right, and which this case law speaks to, both of them, the Superior Court. All right, let's see. Kinloch Court versus Isolate Incorporation. Complainant owns premises in Belleville which are in the possession of defendant under a lease for a term of years, made by complainant's predecessors in a title. The bill charges that the defendant has failed to keep the demised building in repair and has suffered it to become dilapidated. A decree is prayed that defendants pay thrice the damages to be assessed for the waste, and that defendants should lose the premises and its tenancy by termination. On filing the bill, council moved that a writ of waste issued pursuant to revised statute 2:79-3. So everybody's using common law that actually belongs to us, the Anglo-Saxon Berbers, the descendant of the Plantagenet crown, because this is where they amended their law from. The Statute of Marlborough, the Statute of Gloucester, the Statute of Westminster II, which actually came from the Donors Conditional Books, which I'll prove it in a second, which is still in the damn statute today. Okay? So they're bringing these arguments in court, and they ain't even the people. They aren't even the people in which the court is making the decision on. So imagine how more of an impact it's going to help us in this matter. And these cases from 1999 and 1995. I mean, 1945. What's it, 1945? 1946. All right? Complainant owned premises in Belleville which are in the possession of defendants under a lease, okay, a contract for a term of year made by the complainant's predecessor in the title. This can only be what we call fee simple. Okay. The bill charges that the defendant has failed to keep the demised building in repair and has suffered and it has become dilapidated. This is because they have what they call an easement, which is a non-possessory use and property that you don't own. Okay. 99.9% of the people who are watching this or who won't watch this or will be watching this or ignore this are in that position. You own that property fee simple. And that was done by common recovery because somebody else stole it and then put it on you. They gave you the burden. Okay? It said any person may have a writ of waste out of chancery against any person holding by dower, courtesy, or otherwise for life, for a term of years, or other term, as well as against guardians. And whoever shall be convicted of waste shall lose the thing or place wasted and shall be liable in thrice the damages accessed against him by a jury. You hear that? Okay? So they're using our feudal remedy, our arguments which are preserved for fetal relief. Okay? How? It says it right here. The section of our revised statute of which complainant relies, same thing you read in the first case, is a relic of the Middle Ages taken from the statute of Gloucester by Edward I of the Plantagenet crown, which Governor Patterson followed the statute of Gloucester and other English statutes and drafted an act for the prevention of waste, which was passed March 17, 1795, which is now under New Jersey Revised Statute 2A65-3. Okay? This statute has retained a place in our books and with minor changes now appearing under New Revised Statute 2A. All right, or 2. It was a principle of ancient English law. No action could be maintained in the King's Bench or Common Pleas without the sanction of the King's original writ. Now, I'm the king, right? And this is a 1946 case and 1999 case in regards to bringing a claim based upon somebody wasting property that wasn't given to them, or if it was, they're not using it for the intention in which it was preserved, i.e. the grant, i.e. the fiefment. Okay? You must understand that. It was the principle of the ancient English law that no action could be maintained in the King's Bench or Common Pleas without the sanction of the King's original writ, which issued out of chancery as the officia justitiae, if I'm pronouncing that right. Justitiae. I probably am pronouncing it wrong, but forgive me. And which gave to the law court jurisdiction of the cause. The writ ran in the king's name and directed the sheriff to command the defendant to appear in the King's Bench or the Common Pleas as the case might be, there to answer the complaint, which was briefly stated in the writ. If the defendant failed to obey, process known as judicial writs issued out of law courts to compel his appearance, in which are several specimens of original writs. All right? In the colony of New Jersey, the Old English practice was pursued. Actions in law, courts were begun by original writs which issued out of chancery. The practice began to change at the close of the Revolution, when the legislators directed that actions of debt should be commenced by summons or capias, judicial writs which issue out of the law courts. Then in 1799, it was enacted that the further process to be made used in personal action in any courts of the state in the case where the plaintiff is not entitled to bail should be by summons. Okay? Summons. That's usually done by the clerk. All right? It has notice of summons. All right? So as we can see it in the Chancery Court as well as the Special Civil Court, that they recognize that law of waste under the common law was actually amended or incorporated into the laws of the state under 2A 65-3. Okay? Very, 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 very important. All right? Before we go into the revised statute, seeing the interpretation of the language in the statute, let's first review the statutes that were enacted for my ancestors, called the Statute of Marlborough, the Statute of Westminster, and the Statute of Gloucester. All right? All these resulted from what we call the anarchy. Okay? The anarchy existed in 1164, which called for what we call the Size-Clarendon Constitution, part itself. The Size-Clarendon Constitution was created in 1164 as a result of the anarchy, which there was a need for courts to be created called the Assize Court, which is called the Assize-Clarendon Act of 1166, which we'll go to first before we move forward. All this was done by Henry II, son of Godfrey, the fifth Count of Anjou, son of Folk, the ruler of Jerusalem, i.e., the ruler of the Garden State, which we are in now, New Jersey. Everyone give me a thumbs up if you like the content. Assize of Clarendon was an act of Henry II of England in 1166 that began a transformation of English law and led to a trial by jury in common law countries worldwide, and that established assize courts. Okay? Assize Clarendon was an act of Henry II in 1166 to begin the transformation of English law and led to a trial by jury in common law. This is where your court systems that you have today get their origin from. Okay? The Assize of Clarendon Act by Henry II, the father of who? Henry III, the father of Edward I, Edward II, and Edward III. Okay? All descendants of the Plantagenet crown, because why? They were heirs. All right? We must comprehend that. So this is why you have what they call the Establishment Clause. All right? New Jersey or the United States have what they call the Establishment Clause. And the Establishment Clause, the president is either the Bill of Rights, Articles of Confederation, the Constitution of Pennsylvania or New Jersey, or the Clarendon Constitution, which we're going to read right now real brief. Establishment Clause. Your First Amendment, y'all. United States law, the Establishment Clause of the First Amendment to the United States Constitution, together with the amendment of the Free Exercise Clause, is from the constitutional right of freedom of religion. Okay? Freedom of religion. Those are based upon the presidents of what? The clause was based upon a number of presidents. That means that these presidents existed before the Establishment Clause or your First Amendment or your freedom of religion. Those clauses that exist before that was either the Bill of Rights, which was preceded by the Constitution of Clarendon, which we just read, by the Assize Clarendon Act of 1166. All right, and that resulted from what we call the anarchy. Okay, our breakdown in the civil government. Not over there, but right here. That was done under the hands of Thomas Jefferson and the founding fathers under Benjamin Franklin, all of those, when they broke away from the crown here in New Jersey. Okay, through what we call the petition by William Franklin called what was it called? What was it called? It was called the road. Oh yeah, Two Roads speech to New Jersey legislator. So write that down. The Two Roads speech to New Jersey legislator, and William Franklin telling them that to choose prosperity as being a part of England rather than choosing the fire. Okay, as opposed in England, we must comprehend that. All right. So where were we? Establishment Clause. The Establishment Clause, where you get your First Amendment or freedom of religion, was established from the Constitution of Clarendon or the Bill of Rights of 1689, when that goes into what we call a house of storage. So we can't use that. All right. We can't use the Articles of Confederation. All right. Nor can we use New Jersey's or Pennsylvania's Constitution. All right. We can't use either one. Right here. You see it. Historical background of the Establishment Clause is either the Constitution of Clarendon, going back to the 12th century, or the Bill of Rights, i.e. the 17th century, or the colonial New Jersey and Pennsylvania Constitution. Okay? Or the freedom of religion, which Thomas Jefferson presented to the House of Burgesses, which actually did away with entail estates by virtue of doing away with what we call the primogeniture, a way of conveyance of land, a way of lottery of seats. Okay? This is how you have to talk if you understand English political science. This is how you have to talk. All right? Moving forward. All right? Let's see. So we know that the Constitution of Clarendon was rooted in the anarchy or the breakdown of anarchy, which was a result of invaders claiming an interest in the estate, which you have now, right? Which caused a violation in the common law dealing with waste, all right? Because that's the title of this lecture. Waste, common law, Anglo-Saxon property. You have mismanaged the property of the Anglo-Saxon Berbers. Okay? And the Constitution of Clarendon was put in place, and the courts that were established by the Clarendon Constitution were put in place. So when that day came, we were able to seek due process of law, and of course, under that Constitution of Clarendon. Okay? We must comprehend the consciousness. Okay? We must comprehend the consciousness. Let's go into the sides of Clarendon. Sides of Clarendon was an act of Henry II of England in 1166 that began transformation of English law and led to a trial by jury in common law countries worldwide and that established the size court. So it's not just, it says worldwide. Did you hear that? It said worldwide. Worldwide. All over the world. Okay? All over the world. After the side of Clarendon trial by jury developed, though some historians say in beginning of the jury system predate this act. The side of Clarendon did not lead to this change immediately. Recourse to trial by contract was not officially rescinded until 1819. Okay, so let's get into this. Statute of Gloucester, or the Statute of Marlborough. That was the first one, because those were all incorporated under New Jersey Revised Statute Title 2A. Okay? Statute of Marlborough, Statute of Westminster, and the Statute of Gloucester. We're just going to talk about all three. All right? Let's see. Passed by who? Henry III. Henry III was the son of John, the son of Henry II, the son of Godfrey V, Count of Anjou, the son of Fulk, the ruler of Jerusalem. Okay? New Jersey is called the Garden State. Okay? The Statute of Marlborough, a law passed by a Parliament of England, not Scotland, not Ireland, not France, not Germany, but England, reigned by Henry III in 1267. The law comprised 29 chapters, which 4 are still in force. Those 4 chapters constitute the old piece of statute law in the United Kingdom, still in force in 2024. The statute is so named as it was passed at Marlborough in Wiltshire, where a parliament was being held. The preamble dates it as the 2 and 15th year of the reign of King Henry's son, King John, and the Utus of St. Martin, which would give a date of 18th of November 1267. Utus, and is an archaic term to denote the 80 days and inclusive counting. So 7th day in the normal English usage after the event in the case of the feast of the day of St. Martin. All right, let's read a little more. These are some of the chapters within the statutes of Marlborough. Okay, Marlborough or Marlborough, and we do have a township here called Marlborough Township. Okay, I'm pretty sure it's named after Marlborough Shire. All right. So this is some of the distresses that we're going to take a look at real quick. Chapter 1 through 4 and through 15, distresses, which seek to govern the recovery damages, distresses, and make it illegal to obtain such distresses outside the legal system, are collectively referred to as the Distress Act of 1267. All right. Chapter 1 announces the intentions of the act, noting that a recent commotion had led to the lords and several other persons refusing to submit to the king's court and taking distresses at their own pleasure. It makes it illegal to obtain distresses for damages other than through the courts, regardless of class or estate. It punishes extra legal attempt to obtain such distresses made after the passage of the act with a fine to do so. All right. Focal point is chapter 21, 22. Chapter 21 and 22 also cover distresses. Chapter 21 requires the sheriff to return livestock wrongfully taken from any person upon that person request without delay. Chapter 22 requires a royal writ for distraint against a freeholder and prohibited coerced testimony against a freeholder without a royal commandment. Now, freeholders were the ones who stole it in the first place by way of common recovery, which is changing entail estate to fee simple through the Common Recovery Act. all right, which was abolished. We can go to New Jersey Revised Statute, colon 46:3-10. It'll tell you right there in the statute. I don't have time to go over it right now as a result of what I have to cover, but there you see it right there. The chapters govern the statutes of Marlborough, all right, which was mentioned in those two court cases that were all incorporated under the Judge Revised Statute 2A, governing the administrative of criminal and civil proceedings. Okay, we must comprehend that. So that was the statutes of Mortimer. What about the statute of Gloucester, 1278? I mentioned that as well. Let's see what that states. The Statute of Gloucester is the piece of legislation enacted in the Parliament of England, not Ireland, not Scotland, not Germany, not French, etc. It says England. The statute proclaimed Gloucester in August 1278, which was crucial in the development of English law. Okay? English law. The statute of Gloucester in the ensuing legal hearing were a means by which Edward I tried to recover legal authority that had been alienated during the reign of his father, King Henry III, which was what we call the Statute of Marlborough. That was in 1267, all right, passed by Henry III, who had been made a virtual tool of baronial party led by Simon de Montfort, okay? Edward I recognized the need for legal reform and considered Parliament as a means of buying popular support by encouraging local subjects to petition the king against his own barons and ministers. This is called advocacy. This is called lobbying, okay? Very important, all right? Several actions that lied under this statute, under statutes of, what was it, Gloucester? Just Gloucester? Yeah, Gloucester's. Let's read them. Civil actions where damages should be recovered. In what case, knowledge of the plaintiff should not state an inquest. Any alienation of land by a tenant by the courtesy with warranty should be void. In what cases, affidavit is maintainable against a tenant in a fee farm. Several tenants against whom an action of waste is maintainable. Where diverse heirs shall have one at the death of an ancestor. That's what that means. Asides of mort odisser. That's the death of an ancestor. That's the focal point that we want to focus on, right? Because this is what we're doing, all right? This is what we're doing, all right? We're transferring the estate that our ancestors led to us by way of what we call lottery of season, by way of law, not deed. They didn't have no wills, all right? They didn't create no deeds. They didn't have lawyers to create deeds, all right? It was conveyed by way of the lottery and season process called the twerk and the twift ceremony, okay? I talked about that already. I don't have time to go through it, so all those who didn't comprehend that term, twerk and twift ceremonial, that goes back to Ashton Noblestone. Ashton was the grandson of Alfred the Great, the son of Edward the Elder, okay? We must comprehend your ancestry. Let's go further. In English law, the asides of mort of the ancestor means death of an ancestor, was the action brought where a plaintiff claimed the defendants had entered upon a freehold belonging to the plaintiff following the death of one of his relatives. The questions submitted to the juries was a seize in his demise as a fee on the day whereof he died, and is the plaintiff his next heir? The asides enabled the heir to obtain possession, even though some other person might have a better right to the land than the deceased. All right? Let's see why it's important. Mort the ancestor was one of the so-called petty asides established by who? Henry II in the wake of the asides of Clarendon in 1176. The asides of Clarendon was when they created what they call the assize courts. All right? And that was a result of what we call the anarchy, all right? This is according to the sides of Northampton and the Clarendon, the lord must not prevent the heir having seized forthwith on the ancestor's death, making this almost the final step in the development of the common law of heritability. 4. Either if any freeholder had died, let his heir remain possessed of such season as their father had, and according to the result of the inquest, let restitution be made to his heir. So they only got by way of what we call subfeudation. Subfeudation is governed what we call Queen Imperatoris. Queen Imperatoris was passed by who? Edward the First, and said that the land can only be substituted and not sold on a fee simple as a result of what we call the Adonis conditional bus. The Adonis conditional bus was a extension of the Statute of Westminster's of 1278. Let's look at that right now. Statute of Westminster's. Part so 1285. Yes, twerk and twift ceremony. Thanks, CA. Statute of Westminster 1285. Also known as the Statute of Westminster the Second, or the Statute of Westminster the Second. Like the Statute of Westminster of 1275, is a code in itself and contains the famous clause, "De donuts conditionalibus," one of the fundamental institutes of medieval land law in England. The donuts conditionalibus was a statute passed by Edward the First, which says that you cannot alienate land. Okay. Let's read it. The Donuts Conditionalibus, or the Estates Tale Act of 1285, is a chapter of the English Statute of Westminster 1285. It originated the law of entail, forbidding a landowner to sell his land except to his heirs. You hear that? You see the connection? Follow the rabbit hole? All right. Very, 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 very important. All right. The Donuts Conditionalibus. All right. That's totally different than what we call fee simple. All right. Totally different from what we call fee and simple. All right. Let's see where I want to go now. Now, why is this important? We go to Georgia Revised Statute, all right, you're going to see the Donuts Conditionalibus. Right here. Title 46 governs property. 463-15. When any conveyance, will, or instrument in writing shall hereafter be made, whereby any grantee, devisee, or a person shall become seized in law and inequity of such estate and real estate as under the statutes of Edward the First, called the Statutes of Entail, would have been held in a state in fetail or any type of character. Such conveyance, will, or instrument shall best the estate in fee simple and such grantee, devisee, or persons. Okay? So let's look up statutes entail just to make sure we're specifically talking about the Donuts Conditionalibus. Let's see. Statute. Only thing come up is the Donuts Conditionalibus. The Donuts Conditionalibus is States Tale Act 1285. English Statute of Westminster's originates the law of entail. So you find it right there in New Jersey Revised Statute. Okay? You find it right there. You see not just that, but you see the statutes of Gloucester and the statute of Marlborough, all incorporated under Title 2A of the revised statute by Governor Patterson in the two cases we just read. One from the special civil parts as well as one from the chancery part. Okay? Now, why is this important? Why is this important? All right? Because we're talking about waste. And we know what waste is, the misuse of property by way of damaging it or doing something other than the intent on which it was described for their use. That's what you call trusteeship. We must comprehend that. So let's go to the statute. First, let's go back to the case law. I'll come to my closer. So in regards to New Jersey statute annotated 2A65-3, that's New Jersey statute governing administrative of criminal and civil proceedings. Okay? So it's said in the case law, Birch versus Hangley, a 1999 case, Superior Court Law Division, Special Civil Parts, in Monmouth County. It clearly says, for the record, for the court record, not the public record, but the court of record. Okay? Totally different. All right? Any civil action may be maintained in Superior Court against the tenant, and upon finding that waste has been committed, treble damages should be asserted on granted, and the defendant should lose a thing or place. That means he can be ejected from it. Although the genesis of the statute dates back to England when the Statute of Marlborough was enacted in 1267. So that's the first one. That was preceded by the Statute of Gloucester. Then that was preceded by the Statute of Westminster, which was preceded by the Statute of the Donors Conditional Above in lieu of Queen Imperatrix. All right? See it right there. Okay? And it said that Governor Patterson incorporated it into New Jersey statute annotated 2A. Right here. The section of revised statute on which complainant relies is a relic of Middle Ages, taken from the Statute of Gloucester by Edward I. We just seen him in Title 46. Now we see him in Title 2A. Go figure. Governor Patterson followed the Statute of Gloucester and other ancient English statutes and drafted an act from the prevention of waste in 1999 and backdated going back to 1278, involving or closing the gap from Edward I to the present, because you see Edward I, who passed an enactment, still preserved in the statute in 2024. Okay? And it said that Governor Patterson followed the Statute of Gloucester and other ancient English statutes and drafted an act for the prevention of waste, which was passed by the legislature in 1795. His statute has retained a place in our hooks and within the minor change with minor changes now appears under Title 2A of the revised statute. Do you hear that? That's bad. So let's go to the statute and read it for ourselves. In closing, New Jersey Revised Statute 2023, Title 2A, Administrative of Civil and Criminal Justice. Okay? Yes, the justice system. Actions for waste for treble damages. Okay? So this is the statute of Edward I. Civil actions may be maintained in support of Superior Court and the tenant, and upon finding that waste has been committed, treble damages shall be accessed or granted, and the defendant shall lose the thing or place wasted. Okay? This was incorporated from the Statute of Gloucester, the Statute of Westminster, the Statute of Marlborough, as well as the Donors Conditional Above, because it was passed by Edward I. Okay? We got another one. 2A colon 65-5. In closing, Administrative of Civil Criminal Justice, Section 2A colon 65-5, action for waste by an heir. Treble damages. So an heir. We are heirs. I am the heir. I am the one that are able to make a claim to the estate as a result of an escheatment. Escheatment only happens within the state. When they know English people, the only person that can claim the land is the crown, and I represent the crown by way of what we call corporation. So look at Chisholm versus Georgia for that. All right. So it says, any heir may maintain a civil action for waste or destruction of his inheritance. Did you hear that, y'all? Whether such waste occur in the lifetime of his ancestors or thereafter. The judgment in such an action should be for the recovery of the inheritance wasted or in money value if such recovery is impossible, and treble damages. Did you hear that, y'all? I don't think y'all heard that. It said any heir. So what heir, if any heir can do it, what heir has stepped up to do what we read based upon the statute of Gloucester, Marlborough, and Westminster? What heir has done that? We incorporated to do that here at the Third Temple English Church of England. Okay? We incorporated to do just such a thing, to bring a claim because they have laid waste to the Anglo-Saxon property. We are heirs, Anglo-Saxon Berbers. Those who created this nation under the Naturalization Act of 1790 only did it based upon the color of skin. And their color of skin were light skin, fair skin. Very important. All right. Let's go to section 10 of that same statute before I close out. Section 10 of Title 2A, i.e., the statute of Edward I. Civil action in Superior Court. If the tenant of a particular estate neglects or fails to take and keep possession of the real estate and maintain the same free from waste within 2 months from the date of the service of the demand, so to do as provided by Section 2A 65-8 of this title, or neglect or fails to pay the taxes or municipal liens upon such real estate chargeable by law to him within 3 months from the date of the services of the demand, so to do as provided by Section uh, 2A65-8, the remaining reversion or the other person entitled to the ultimate enjoyment of the real estate may maintain the civil action in Superior Court for relief of such premises. That's not the statute I even wanted. Let me find it. Bear with me, y'all. I know I got it. Just find it. I'm almost there. Give me a second. I'm almost there. 1 second. Is it 10? Let's go to 4. It might be 4. If it's not 4, I'm going to move on. It might be 4. No, I can't find it. All right, I'm going to move forward. All right, so let's see. All right, where we at now? Okay. Let's go here. Ways between partners, tenants in common, or joint tenants procedure. Still under Title 2A. When 2 or more persons hold property in common as tenants in common or joint tenants, and one or more of them commit waste, action shall lie against the person or persons committing the waste. After judgment in such action, the defendants may elect either to have the common property partitioned or to give such security as the court should deem sufficient, not to commit any further waste. If the defendant shall elect to have the property partitioned and the part assigned to him to include the portion of the property wasted. If the defendant does not elect to have the property partitioned, or if the waste exceeds the value of a share of the property, the plaintiff should recover damages thereof against such defendant. There was one that I had here for trespass. We'll just make sure, see if I can find that. Once again, we're talking about waste. Okay? We're talking about waste under common law definition of waste. Uh, so we read 2A65-5, which says the heir may recover based upon the inheritance even after the lifetime of his ancestors. Okay? Any heir may maintain a civil action for waste of destruction of his inheritance. You hear that? Whether such waste occurred in the lifetime of his ancestors or thereafter. The judgment in such an action to be for the recovery of the inheritance waste and the money of value in such recovery is impossible, and recovery is impossible, and treble damages should be awarded. Okay? You see it right there. All right, let's go for one more. Section 6 of that statute. When any tenant for a term, including a life tenant and property demised to or held by him, has or shall lease or grant his estate in the property to any person, and shall thereafter continue to occupy such property or to take the profits thereof, and shall commit or suffer waste and destruction thereof, the owner, remandment, or reversion of such property may maintain a civil action against such tenant and recover from him the property wasted or any money valuable in treble damages, provided such tenant was liable for waste before he leased or granted the estate, but not otherwise. Let's see if we can get one more in here. I'm trying to find that one. see one for trespass. I don't see that one. All right, so let's move forward. All right, so we talk about wasteland, okay? I mean, we're talking about waste property. When you got property and it's being wasted, that means that you mismanage it. And if you're not instructed on how to manage the property, that means that when you got there and the property was there and you don't know how the property is to be managed, that means that it becomes a wasteland. Okay? It becomes a wasteland. So what is a wasteland? Okay? Let's define a wasteland before we go into waste people. Okay? In closing. Wasteland or wasteland may refer to desert or barren area, an uncultivated area of land whether wooded or not, whether common land or not. Okay? So that means that if you are not a planter from the plantation ground and learn how to till the land, all right, to um um to foster the land, to make the land fruitful, that means that you are a person uh, that does not manage the land right and the land become a wasteland. That means you're a wasteful person because you wasted the potential of the land. Okay? Very, very, very important. And close. Because only people waste things. Okay? Only people waste things. No other animal on the planet, no other organism on the planet, no other thing on the entity on the planet wastes things. They make use of it. It's very important to understand how the concept of waste came into being, especially dealing with it from law. Okay? And we just know that the origin of waste law comes from common law of England as passed by the common law kings. Edward I, Henry III, Henry II, his father Godfrey, fifth Count of Anjou, because these were the kings of Jerusalem, who we are the new heirs. We are the citizens of them, and we have the right to bring a claim if the property is not being managed right based upon the land. Because if it becomes a wasteland, then that means the land, the resources, and all that comes along with it has been wasted as well. In my closing. So we have an article here, how England waste people became white trash in the United States. Okay? I didn't write this. White trash, redneck, clay eater, cracker. This is only a partial list of all the sneering names developed over 100 years to stigmatize poor white people in the United States. In her new book, White Trash, The 40 Years History of Class in America, Nancy Eisenberg traces the evolution of language, perception, and public policy behind this sorry story. Listen, everyone. Key myths exposed. Eisenberg first takes aim at one of this country's most enduring falsehoods, that the United States is a classless society with equal opportunities for all. Nothing could be further from the truth. Long before the United States was a country, it was a capitalist enterprise. Okay? Companies set up to trade with Native American tribes were the first to recognize the development of land as a profit bonanza. Back in England, wealthy men began to plan for its settlement. Okay, so they were scheming, conniving. Okay, all of these well-heeled social planners had one thing in common: the colony would be the perfect place to dump Europe poor waste people, as they were called. These landless, often unemployed people were viewed as lazy and above all unproductive. They included prison convicts, often simply debtors, who were given a one-way ticket to North America, managed them to clear the wilderness, would provide needed labor in the colonies. You hear this? Wasteland. The other key myth Eisenberg uncovers is the contrary to national law. The United States was not settled primarily by Puritans seeking religious freedom, but by scores of indentured servants. Puritans were only a fraction of the population. Life for most newcomers was harsh. Indentured servitude could last a decade or more. Punishment for infractions ranged from whipping to lengthening the period of servitude or having a mother's bondage transferred to her children. This is called um, uh, Secretary of Trim. All right. What was it called? Uh, what's the term? Uh, Secretary of Trim. Status of the mother. All right. Servants were both white and black, with few distinctions drawn between them. Okay. The birth rates of racism. Eisenberg treatment of Bacon's rebellion in 1676 illustrated a central weakness of the book. Although she is extremely detailed in her description of events, analysis is slim. The rebellion consists of black and white indentured services and those recently freed. Besieged, captured, and burnt colonial Jamestown, Virginia. This scared the colonial rulers class to death. All right? Very, very important. Let's go more in depth to that. All right? White trash. In closing, the terminology. The expression white trash probably originated in the slang used by enslaved African Americans in the early decades of the 1800s. It was quickly adopted by richer white people who used the term to stigmatize and separate themselves from the kind of whites they considered to be inferior, and without honor, thus carrying on the ancient prejudice against menials, swineherders, peddlers, and beggars. Poor white trash signifies the bad poor, not the romanticized noble and hardworking good poor. One word applied to such people was tacky or tackies. There, there may have been any intermediate times when it was used to describe those who may have been wealthy but had no family roots or good breeding. It now generally refers to anything that is cheap, shoddy, gaudy, seedy, or in bad taste. Jacqueline Jarrell Wilson argued that the term is partly rooted in British class and ethnic conflicts, which tended to privilege English people over the Scots, Welsh, and Irish. Though she notes that there also are hierarchies within this framework, such as the early Scottish Irish Presbyterian immigrants who saw themselves as better than later Irish Catholic immigrants. Let's see. In her book, White Trash, Nancy Eisenberg argues that the British saw the American colonies as a wasteland and a place to dump their underclass, those people they call white waste people, the scum and dregs of society. The early term waste people gave way to squatters and crackers, used to describe the settlers who populated the western frontier of the United States and the back country of some southern states, but who did not have title to the land they settled on and had little or no access to education or religious training. Crackers were especially used in the South. Eisenberg also listed other derivatives names that have been used to refer to poor white: waste people, off-skirting, lubbers, bog trotters, rascals, rubbish, squatters, crackers, clay eaters, tuckies, mudskills, scalawags, bar hoppers, hillbillies, low downers, white niggers, degenerates, white trash, rednecks, trash, trailer trash, the swamp people. Okay? So it's very, very, very important to understand waste law. Okay? Understand waste law. Okay? Because by understand waste law, you understand how the land became a wasteland. All right? When it was conquered or invaded. All right? So we call acquisition of sovereignty or adverse possession or what we call acquisition. All right? We must understand what's going on. All right? So with that, make sure I covered everything. I think I got everything covered. So once again, I just want to close out on William Franklin's plea to the founding fathers. Okay, very important. William Franklin's plea to the founding fathers, because we know when that sun hit him, that sun of righteousness bringing healing into the west is going to scorch a lot of people. All right, it's going to scorch a lot of people. The scorched people, the waste people, are the adverse possessors. Exactly, you're right. All right, those who took the land by force to eminent domain as a result of their treatment power, which only resulted because of interstate. All right. So in closing, the era of fulfilling between father and son will come to an end with the advent of the American Revolution. Benjamin Franklin, sometimes referred to as the reluctant revolutionary, hoped at first that differences with the British could be resolved. When he did join the revolutionary cause, though he was all in and pursued goals of freedom and liberty with vigor. He expected William could be persuaded to do likewise. Hadn't William always followed his father's lead before? You need to ask yourself, are you following the leads of your leader based upon what you're knowing, you're realizing today? Because if you are, then that when the king comes back, all right, or when that son of righteousness come back, you're gonna be scorched by him because you turned away. All right. Thus, this time Benjamin would be bitterly disappointed. In August 1775, Franklin traveled to New Jersey to convince William to join the rebellion. He told his son he would be accepted with open arms by those opposing the king and could easily win a generalship and an army formed under George Washington. William refused, remarking that if his father was determined to set the colonies on fire, he trusted that he would take care to run away by the light of it. You hear that? As a lawyer, William believed America's best chance to succeed lay in remaining with the Britain. He also believed most Americans would not support the rebellion. William Brake, with his father, became very public with his two-road speech in the New Jersey legislature, urged them to refuse to endorse the newly formed Continental Congress and take the road to prosperity as part of England rather than the road to civil war or anarchy. His efforts were to no avail. All right. So with that, understand that I am King Clifford Jefferson, ascendant of the Plantagenet crown by way of what we call Godfrey the Fifth, Crown of Anjou, son of Falk, ruler of Jerusalem, the father of Henry II, the father of John, Richard I, Henry III, the father of Edward I, the father of Edward II, the father of Edward III, the founder of John Gaunt, and John Gaunt set the course for us to be in the situation that we are in now. So without further ado, it's always a privilege to come here for my people, understand that your land has been put to waste by adverse possessors through acquisition of sovereignty. Those who are opposing to be the sovereign, and they are in fact not. Case law provided that I am in fact the sovereign. The Superior Court is my bench, and those officers are my counsel. It's up to you to find out, are you a part of my council? If you're not a part of my council, then you must be a subject. If you're a subject, you must become a national. If you're not a national, i.e. a subject, i.e. a citizen, then the only door left for you is being a foreigner, okay? A naturalized citizen. And if you're not a foreigner being allowed to be here, that means that you're here by way of what we call conquest, squatting, white trash. So with that, I'm going to greet you as I always greeted you in the ways of my ancestors. That's in peace and love. Hope you like this lesson. Leave your comments in the chat box as well as in your comment, as well as all your donations to the Third Timothy English Church of England or $ Clifford Jefferson L. And once again be counted amongst the righteous. Peace.